training, we're going to be discussing mediations versus arbitrations, okay? We get a lot of people that get a little confused on the difference between, what is a mediation and what is an actual arbitration. Now, both are part of the purchase agreement. All of the purchase agreements, such as your residential purchase agreement, your income producing purchase agreement, your vacant, your business opportunity purchase agreement. So all of the language on arbitrations and mediations are part of the process through the California Association of Realtors. So let's dive in deep into the conversation real quick and really get an understanding of what the differences are and the importance of when a mediation happens and when we have to escalate it into an arbitration. All right. A mediation is a neutral facilitator, okay? Someone that's a referee, all right? There's an issue with the transaction, the process, then a facilitator can neutralize that by being a referee. That's what it really, a mediator does. It's like you can see the diagram right here, the green diagram versus the angry person and the not angry person, right? Basically, his and her role is to hear both sides of the story and try to neutralize that from getting any worse, okay? And that can be diffusing the situation. That can mean from canceling the transaction or even potential lawsuits or complaints. The mediator is just as a referee, okay? Like a boxer, two boxers fighting, the goal for the referee is to make sure that they are both in accordance to the rules and regulations, right? Well, a mediator is no different. A mediator's job is to listen based on the agreements, and it can be any agreement, such as your purchase agreement, your disclosures, your addendums, escrow, any documentation while you're in the process of a transaction. That's where you can hire a mediator or someone that's really good at mediating. Guess what? You as a real estate agent can mediate a situation too. Your job is to navigate, right, and close, make it a win-win for all parties. Well, that's what we call mediation, okay? Maybe you're not licensed to do so, but we practice mediations all the time as we, navigate these transactions. Now, a mediator helps the parties to negotiate a solution. Question? Do we have a question? Okay. So a mediator is a person that can help the parties to come to a resolution, okay? And that resolution can ultimately make it a win, because again, the last thing that we don't want is for the transaction to fall apart, right? You represent the buyer, I represent the seller, and then there's an issue regarding request of repairs, and we cannot come into an agreement, okay? We cannot come to an agreement, and then ultimately a mediator will step in there, listen to both sides of the story, right? I'll hear your side of the story, and then the other party side of the story, and then come to a conclusion. Now, on top of what we just discussed, also is the paperwork involved. I want to know what was done, what was said that ultimately took us to, this direction. It's no different than when you're driving, right, and you have to go off course, right? Either because of a detour, traffic, accident, and we have to go in a different direction, but we still come right back and we go to our destination. Well, mediation is the same way, ladies and gentlemen. Mediation is the position to hear every party and come with the best solution to resolve it, to make it what we call a win-win. That's what mediation is. And as you can see the presentation, he or she is a neutral facilitator, helps the parties to negotiate the solution. The parties to the mediation control the outcome, okay? See the gentleman in front of you, part of the presentation. That can be a mediator, that can be a manager, that can be a team leader, that can be the real estate agent. Mediation can be a seller or a buyer, or it can be a transaction, meaning there's a buyer and a seller involved. The outcome is really the outcome of what we can agree to. Doesn't mean that it has to be the right answer, as long as we can compromise and come to a resolution, okay? Maybe in this scenario here, it's a seller, let's say, and the seller wants to sell their property, right? But we have the husband and the wife that are not seeing eye to eye. Or it may be a situation where they're getting a divorce and they don't see eye to eye, but they're in a position that they have to sell their property. You as a real estate professional have to step in, be the neutral party, but also be the facilitator to make sure that they both go in the direction to get this property sold. Many of you may come into that scenario where you go on a listing appointment and you're dealing with a very sensitive, husband and wife. They're in the verge of separation, the verge of, starting the dissolution of divorce, or maybe they're already in the chaos of court proceedings and attorneys involved, but part of the decision was to sell their property, and you are caught right in the middle. Your job is to be the neutral party, right? Not to side either party, not to side to the wife, not to side to the husband, but to be that neutral party to accommodate both on this situation. That's what mediation is. Driving them to get to an agreement. It may not be the most pleasant agreement. The husband may not see it, but agrees to it, and that's the win. Does that make sense? Okay.
Both sides have to.
Well, both sides typically will either disagree or agree. As a mediator, if there's a disagreement, they don't see eye to eye, or there's, a frustration point where something is not going in the direction that needs to go, this is where you have to step up. Now, mediation is a very, very sensitive scenario. And as a facilitator, trying to hear both sides of the story, your goal is to find the solution that will push them to go through the process, close the deal, the solution to allow the buyer to continue with the process to close the deal, right? Because it's both sides. If you represent the seller, getting them to close the deal. If it's working the buyer, getting them to close the deal. And if there's some issues or no alignment to this, how do we put them into alignment, right? Where they see eye to eye, or at least agree to continue. And that's where mediation comes into, is really a settlement, okay? And as it states here, if mediation fails to settle, the parties can go through the court or arbitration and let the judge or the arbitrator make the final decision. And that's, again, where the difference between mediation and arbitration. And we'll dive deep into the arbitration that aligns more of a court hearing. And I'll explain, because I've been in both scenarios. I've been in a mediation, but I also been in arbitration and also been in court as well. So let's talk a little bit about an arbitrator is like a judge who listens to the evidence and makes a final decision. So let's just role play here for a bit, okay? And I have Victor in the office, and Victor is representing the buyer. I am representing the seller. The buyer had put a request of repair, and that request of repair was for $10,000. I presented the request of repairs to the seller. The seller says, I will not do $10,000 of buyer's request, but I'm lenient and I'm willing to work with the buyer. So I'll agree to a 5,000 credit for request of repairs. So I go back to Victor and I say, hey, Victor, after a careful consideration and speaking with the seller came back with good news. Okay. The good news is that the seller is willing to give $5,000 of credit towards the repairs to your buyer if they're willing to release, physical inspections. So Victor gets the information from me and now talks to Victor's client, and Victor's clients disagree. Victor, in talking to the buyer, says, look, I have some great news. I was just talking to Simon, the listing agent, and we put in a request for $10,000 of credit in lieu of the repairs, but the seller came back with a $5,000 request of repairs credit to help you. But the buyer is still not completely happy. No, there's a lot of issues with the property. I don't feel very comfortable with the 5,000. Can we ask for a second request of repairs? The answer is yes. So Victor prepares a second request of repairs, sends it over to me, and does not call me to prepare me for it, just sends an email. I receive the email and I think, okay, so obviously the buyer did not agree to the 5,000 that the seller was going to credit the buyer, but now the buyer is asking for 1,000 instead of the 5,000 that the seller was going to give. So I get it, and I'm already like, okay, how come Victor did not at least reach out to me, prepare me that he was going to send out a request of repair or a second request of repair? So I'll call Victor and then I'll talk to Victor. Hey, Victor, just received the request of repairs number 2, and now the buyers are not happy with the $5,000 that the seller was gracious enough to give. And I'm going to prepare Victor, and I'm going to tell Victor, by all means, you know that all properties are sold as is condition, meaning that the seller does not have to give any repairs, any credit, or even a price reduction. Now, I will present this to the seller, but there's no guarantee that the seller will increase that amount from the original. I'll do my very best, but at the end, it's the seller's decision. I'll let you know. So now I reach out to the seller and say, Mr. and Mrs. Seller, I just got notification from the buyer's agent. They truly want this property, but $5,000 is not sufficient enough. The buyer is now requesting $8,000 from the original $10,000. So they have declined the $5,000 that you provided. And then the seller says, wait a minute. I will only give $5,000. The buyer takes it or leaves it. Okay. And this is coming right from the seller's mouth, right? I'm only giving $5,000. That is it. Now, this is where the mediation comes into play, ladies and gentlemen. This is why you have to know how to finagle this approach. Okay. Because yes, your position in representing either party is to take care of their best interest. With that being said, my number one goal is making sure that I protect my client, right? But I'm also looking at it from all angles. And that angle is, how do I save this from falling apart? Because I don't want to start over. The buyer's agent doesn't want to start over. And typically the buyers and sellers are in a little dispute. Your job is to resolve that dispute, settle it, or we can continue the process. So I'll step in and now be an advocate for the buyer and the buyer's agent. And I would talk to my client, Mr. and Mrs. Seller. I understand that they did put out a second request for 8,000, but it's a negotiation. I've already explained to the buyer's agent, Victor, that all property are sold in its as-is condition. There's no promise or guarantee that the seller will give the 8,000. My job is just to facilitate and send over the request. The ultimate decision maker will be my client, who will give me the answer to yes, allow the extra credit, or no, it stays at 5,000, or the seller decides just to cancel with the buyer. But part of this, Mr. and Mrs. Seller, is my job is to navigate this and make sure that you are completely satisfied with the entire process. And with that, my goal is to make sure we're going in the right direction. So I'm only presenting what the buyer's agent has requested. What is your position here? Well, the seller says, well, Simon, I want to know what your opinion is. How do I navigate this? What is your take on this? Well, your response as a professional real estate professional is, well, Mr. Seller, this is not my property. This is your property. I work for you, so you got to tell me your position. Okay. Your position is either to stay with the original agreed upon 5,000 from your end agreed upon, right? 5,000, or to accept the 8,000, or cancel this deal, or meet somewhere in the middle. Well, can you explain it a little bit more, Simon, of meet in the middle? Well, yeah, they're at 8,000, we're at 5,000. Let's meet smack in the middle, wherever that is, right? So 5 and 8, there's a $3,000 difference. So 1,500 is the middle, right? So we'll go up 15, and the buyer will have to agree to not the 8,000, but less than that. So that puts us at what? 6,500, right? 65 from the original 5 and their original 10, right? But ultimately meet in the middle from the 8,000 and the 5,000 agreed upon already, and meet somewhere in the middle to make this a win. I think, that's reasonable in my opinion, and it continues the process, Mr. and Mrs. Seller. Now, that's just my opinion. You got to let me know if you're comfortable with that. If not, then we stay or we decide to cancel. Now, bear in mind, Mr. and Mrs. Seller, if we do cancel, now we have to put the property back on the market, fish for another offer, negotiate, and the buyer has the right to do their fiduciary duties and investigations. There's no promise and guarantee that the second buyer that we open escrow, that they're not going to ask for requests of repairs, credit, or price reduction. So are you ultimately 100% sure that you don't want to continue, or do you want to work with this buyer? Put yourself in the buyer's shoe. Put yourself when you bought your first home. Now the seller seems to understand the practical approach. And you have been mediating this, even though it's not between two buyers or sellers. It's just between one party, which is your seller, but that's also considered mediation. Now, where it escalates to an arbitration, that gets a little hairy, okay? When there's not an agreement about, whatever position we're at currently through the process, we cannot come to a resolution, then it can ultimately escalate to an arbitration. Now, an arbitration is just no difference than going to court, where there's a judge, and the judge hears the case and determines who is right and who is wrong, who is the going to get the benefits or the credit or the monetary damages or not. Well, an arbitration is similar. Now, typically an arbitration is a retired judge or an active lawyer that will listen to both sides. Now, that's where you've got to prepare for this. And usually, okay, and I mean this from a broker perspective, usually it's between the principals, meaning if there is a dispute between the buyer and the seller, they're the ones that go in front of a mediator and plead their case. We as real estate professionals typically, and I say that in sincerity, that typically we're not involved in that arbitration. Now, they may drag us into an arbitration hearing because we have the evidence. And what evidence do we have? We have emails, we have text messages, we have paperwork, right? Offers, addendums, disclosures. We have emails from back and forth, and that all can be used for evidence. That's part of the arbitration. Now, I remember my first experience on an arbitration. It was in the one of the associations out in Arcadia, California, and I did not know much, but I studied and read a lot of how an arbitration case was. And this was due to an arbitration complaint on, gosh, top of my head, I can't recall, but it's when an agent is hosting an open house and a buyer comes into the open house, but the buyer does not go with the agent hosting the open house and goes with another agent, submits the offer, get their offer accepted, and ultimately close the deal. It's what we call a procuring cost claim. Who is the procuring agent that facilitate this and who is due a commission? That was the complaint that we got regarding an arbitration. The agent that was hosting the open house, as an example, was not even the listing agent. It was an agent helping the listing agent host the open house. Now, the buyer that ultimately bought this property was being represented by another agent. So let me give you the short version of what transpired. The buyer was driving, saw the signs, went to the open house, introduced themselves. They put their name on the registry, looked at the property, fell in love, stepped out, and ultimately called their agent, which was one of our agents here in the office. We'd like to submit an offer. Now, part of the open house, as you are aware, is someone is facilitating or hosting an open house. You should have a registry to have people sign in. And the buyer did sign in. And the buyer did put their name, they put their phone number, and they put their email. And on this registry, there was also questions. Are you being represented by an agent? Are you looking to need financing? How soon are you looking to buy a property? And they answered all those questions. And ironic, we didn't get all that until we actually got entangled in the arbitration hearing. So it's no different than you being an attorney, right? Preparing for a case. You have what is called the opening brief, then the cross-examination, and then your final conclusion. And it was the coolest things, even though it was a little nerve-wracking, but it was fun and exciting to actually experience an arbitration. So if you're ever involved in an arbitration case, be ready, be prepared, and have documentation. Because just like the presentation states, you will have someone listen to the case, provide as much evidence, plead your position, you're able to cross-examine the opposing party where you can actually ask questions. And then the final conclusion to why you feel you're in the right or your client is in the right. Within 20 to 48 hours, the arbitrator will send out a letter or an email of their findings and conclusion. And if there's damages, who is entitled to those damages? Okay, that's what an arbitration is. It's like a judge who listens to the evidence and makes a final decision. No right to a judge or a jury, and no right to appealing in an arbitration. So the awesome part is that whatever the arbitrator, right, who is listening to the case and makes a determination in who is the winning party, there is no jury involved in this arbitration. So it's not a jury of 12 like we traditionally see at a court, right? It doesn't work that way. But there is other people that are listening to the case as well, but they don't really have a say-so to it. They can only hear and factor the decision based on what the arbitrator's final ruling is. But it's it's nothing like a jury trial, right? Where you have a jury that come in here and they make the ultimate decision. No, it doesn't work that way. The arbitrator is the one that makes the final decision based on the evidence, based on the whole process. They make the outcome to it. And no, there is no right of appeal. So if you are the losing party, right? You had a compelling position in an argument, right? But you end up still losing, you cannot appeal that. It's done. It's set in stone. Does that make sense? Okay. Any questions so far?
Yeah, you said that you had that experience with dealing with procuring cause. And I was wondering what was the arbitration about? Because you had the buyer, the person who came and looked at the property. All
right, so let me explain what transpired. Okay, I'm gonna condense it as tight as I possibly can. Okay, so our agent represented the buyer. The buyer and the agent had a buyer representation agreement signed and executed 3 months prior. The buyer and the buyer agent submitted the offer. Their offer got accepted. They were in escrow. The buyer and the buyer agent also went through their due diligence period, were in physical inspections. They also got all the disclosures. And ultimately, the buyer and the buyer's agent closed the deal, and we got a commission from the sale. The argument was that, and we got notification from the manager who reached out to me and said, hey, we have a problem. Your agent who represented the buyer, we have a complaint against your agent, and we're going to go after the commission. We were already in escrow. We were about to close escrow, and the manager or the broker, I can't recall, this was many years ago, said that they had a procuring cost claim against us because we were the ones that influenced the buyer to buy the property. And they wanted to go after the commission because the agent hosting the open house was the reason the buyers ended up buying that property. Okay. So when I got that call, I says, look, I understand your position, but I don't think you have a very good, strong case here. You do whatever you want. We're going to close, and we are not going to pay any procuring costs because open house is for anyone to go and look at a home. Just because the agent shows a house, that means that's their client? They disagree. They thought they were in the right and they were going to challenge this, and they did file a arbitration case against us. And it was done through the California Association of Realtors. 6 months later, I get this letter from the California Association of Realtors saying that XYZ Realty Company and their agents and their broker were going after for procuring costs. And I was like, oh, good. How interesting that this company is going after us. So I reached out to the agent. Okay, I reached out to the agent and I said, hey, we have a procuring cost claim that was filed with the California Association of Realtors, and we have to defend this. Make sure that you have all of the documentations in place. The deal had already closed. We had already got paid. But these arbitration cases can take months before they actually go in front. And she had everything. We had talked to the transaction coordinator, and the TC had all of the paperwork. I says, I need X, Y, and Z. And she goes, did you sign and execute a buyer representation agreement? She goes, yeah, I believe we had one. I need the whole entire file. So they send me the file and I reviewed it. Yes, we had the buyer representation agreement in place, signed and executed by the buyer. Yes, we had the agency disclosure signed and executed by the buyer. We had the purchase agreement signed and executed from the buyer and the seller. We had the escrow instructions and all the disclosures that the seller provided us. And we had all the documentation that closed the file, and ultimately we got the commission. So we were ready. So I told the agent, prepare a summary of what transpired, how this all came to be, because now they're going after your commission. And make sure that you don't spend that commission, because I believe it was about $22,000 that was earned from that commission. I said, you know, whatever your split of the commission, make sure you do not spend this until we go through this arbitration hearing, because we don't know if we're going to win or if we lose, what that monetary damages could be. That can be, we split it. That can mean we have to give them, because they're the winning cause to this arbitration, arbitration hearing. So we were all set, we were prepared, and no difference than going through a court hearing. You know, we had a retired attorney listening to the case. So it started with the opposing party, the manager, the owner, the broker, and the agent were there. And it was myself and also the agent, and the agent's buyer was there too as well. So the buyer had to take some time off to provide us evidence, because that was going to reinforce our position that the buyer wanted to work with our agent and not necessarily with the agent hosting this open house. So it was very interesting. They started, as I mentioned, it starts with an opening case. They said their statement, and then the arbitrator came to us and asked us, go ahead and give your side of the story. Then when we finished our side of the story, then they were able to cross-examine us. And that's where the manager or the broker or even the agent can ask questions to me or the agent or even the buyer that was there. They didn't have a very compelling position. She just said the agent was that she hosted an open house, that she hosted it from 12 to 3, that this buyer came into the open house, they loved the property, and that they wanted to submit an offer. On the registry, ironically, it said one of the questions, are you working with a real estate agent? Yes or no? They answer yes. We also had evidence of the registered lockbox that said that the agent, our agent, opened up the lockbox the following day to show the property once again to the buyer. We had the buyer representation agreement signed and executed, which we presented as well. And we had the contract and escrow documentation, and we had a copy of the commission stating that the deal closed. We also had a profile that the buyer now had ownership of the property. They were fumbling, stumbling, and even the broker did not have a very concise approach. And I didn't think that they had a good position to articulate the reason for a procuring cost claim. So then when it was our turn, you know, I started asking very detailed questions. Well, the agent, I said to the agent, you know, did you have any signs outside, any directionals? She said, yes, we had 6 directional signs out. I said, okay. From what time to what time was your open house? She said, from 12 to 3 o'clock. Did you have other people that walked into your open house that you were hosting? She says, yes, we had multiple families that did come in. Can you tell me how many people that came into the open house? Well, based on the registry, she says, it looked like there was about 15 people that came into the open house. I said, okay. Now, do you feel that because you hosted an open house, that everyone that walked into that property meant that that was your client? Well, no. Okay. What are we trying to do? We're trying to discredit their position, right? That's all we're trying to do. So we're trying to catch the other party, just like an attorney does, trying to expose little gaps in there, so that way the arbitrator or whoever's hearing the case can come to their own conclusion as well. So I asked the agent, did you have a buyer representation agreement? No. Did you submit an offer? No. Did you open escrow? No. Did you close escrow? No. Now, I showed her evidence as well. The evidence is on your registry that you had there at your open house. Can you tell me what number 1 states there? Can you please repeat it? She goes, are you working with a real estate agent? I says, and what is the answer to that question? Well, they say yes. Okay. Again, I'm not saying what she's right or wrong. I'm just providing evidence. Now, you see Exhibit A here, and that exhibit is a copy of the actual Supra that shows the agent in question, which is the agent representing the buyer, showed the evidence that on the following day, she actually went, opened up the house for a second time to go look at the home. And that's when they submitted the offer, that same day, not the day of the open house, but the day after. And she goes, yeah, I see the register on the Supra here, and it does show the agent's name and the time stamp there, that at 2:48 p.m., the agent actually opened up the lockbox. So there was more evidence to that. And then we get to do our final conclusion to that. After doing the cross-examination, the final is, plead why you feel that you are entitled to that commission as an example. Okay. And ironically, when that was set from the opposing party, they went back to the same original reason why they thought that they can have a procuring cost claim against us, because she had hosted that open house. And I was like, in the back of my mind, I was thinking, no, she didn't. After all the evidence that we provided, they saw right through them. They were just trying to see if they can win on this case. Say that again? Yeah, exactly. What I got out of this conclusion was very simple. They were just trying to fish. Most people would have probably been on this. Most people would have said, look, I don't want to go through all this nonsense. let's come to an agreement. Now, if you have a very compelling position, then yeah, the broker, the manager should step in there and try to find that avenue, make it a win-win. If there is
Yeah, what do you think of this room? How you walk in and it's like this?
Okay,
Is it weird?
that is, sounds like Cecilia, but let me mute her. She was not laughing at me, I hope. I already lost my chain of thought here. So the conclusion to this arbitration was that if you have all your documentation in line and you have a very compelling position and you know how to maneuver and ask the right questions, then in any potential lawsuit, arbitration, or even a mediation, you're most likely will probably win on that. And that was the case with us because we had everything aligned. Now, if the agent would have had a different approach, if the agent had some strong evidence, then I can see where this can go sideways as well. Well, she didn't have any very good, strong case on this. Let me flip that around. And this is what I would have mentioned is, well, I had a conversation with the buyer. The buyer was very, very serious, wanted to submit an offer. I explained to the buyer if they had any agent. They explained that they were not working with an agent. I had a consulting appointment with them the following day or after my open house. We discussed all the scenarios. I also told her that I was not the listing agent, but I was hosting the open house on behalf of the listing agent. They allowed me to consult with them. I gave them my business cards. They have my business card in hand, and we submitted an offer. Now I have a more compelling position than not having any documentation. Now, procuring cost claims are very unique in itself and are very sensitive, but it goes back to paper trail. The more paper you have, the more evidence you have, the better position that you will win that case. Because it's more like the scale of the weight, right? The more evidence is going to win. Well, it's no difference in these procuring cost claims when you're dealing with an arbitration. The difference between an arbitration and a court hearing is that there is no jury by trial, okay? And it's no judge. It's either retired attorney or someone that has some law experience to listen to the case. Victor, you had a question.
Were the person who was hosting the open house on behalf of the listing agent, were they in fact trying to become a dual agent at that point? Or trying to go after the buyer?
No.
As well?
No. So the agent that was hosting the open house was not the listing agent. She was an agent in the same brokerage that the agent who had the listing was. But she was hosting it. For example, if Steve was the listing agent, I reached out to Steve. Hey, Steve, I would love to host this week in an open house. Can you give me the opportunity? I go in there and host. I'm doing the open house, but I'm not the listing agent.
Yeah.
That's what happened in this case. So I hosted the open house, and then I met, a party, and the buyers ultimately submitted an offer and bought it, but with another agent. Her claim was that she was entitled to a commission because I hosted the open house. She felt that she was due a commission.
Yeah.
Now, open house means it's open to the public. And that's where I was able to expose the company, expose the broker and the manager, or the owner and the broker and the agent. They didn't really have a legs to stand on this,
The fact is,
It was Pinnacle Realty out in the San Fernando Valley. Yeah, it was a small real estate company.
well, the fact is, an open house, and then it says right there, yes, I'm working, but I have an agent I'm working with. I mean, that seems,
Wow, and that was her fault for not really looking at all of her compelling evidence. Yeah, we got a copy of that registry, and literally that registry says, yes, we're working with an agent. So that right there just shows that the buyer was not being misleading in any way, but the way she put it on the complaint made it look like the buyer was kind of misleading, that they didn't say they had a agent working, which was not true, because this agent, our agent, had been working with the buyer for about 2 to 3 months earlier, looking at property. It just happened to be where this house hit all the bells and whistles, and they ended up submitting an offer. Yes,
It
sir.
would almost go to the insane argument if the listing agent was the one holding the open house and the listing agent themselves sued under procuring cause. On the basis of that, any offer that came through on, that listing agent would then review, would recognize, oh, wait a second, this person came through my open house. It would just the insane argument of, gee, and if this particular buyer ended up being the victorious buyer, I should, as a listing agent, be entitled to all or part of that buyer's agent's commission because they went through my open house.
Correct.
It's just insane.
Right.
100%.
100%. Now, in a arbitration, it can go either way. Just because you have all the evidence, does that mean that it's going to go the right direction? I've seen jury trials, right, where they have all the evidence and the jury still finds the opposing party not guilty. So it's like a coin toss, but it's always best to have all your ducks in a row, all your paperwork, and what really helps you, especially when working with buyers, is that a BRE form, the buyer representation agreement, because it lays it out very clear and concise.
And it has a beginning and end date.
It has a beginning and an end date. Yeah, absolutely. Absolutely. Arbitrations are private and the parties choose the arbitrator. Here's my position on this, because I've experienced an arbitration firsthand. We didn't have a choice for the arbitrator. One was assigned to us. They had assigned it on a neutral area, which was not in the South Bay and not in the Valley. So both parties, we had to go to the San Gabriel Valley, which was a neutral area. So there's no bias, in my opinion, but we didn't have a choice. Now, it was in a conference room similar to the training room. And, we had the arbitrator there and the opposing parties here. We had the buyer, the agent, myself, and then we had the owner, the broker, and the agent here in her position. And what's so funny about everything is because the principal buyer was not able to hear all this. So the buyer had to be outside. So when we brought him in, he just laid it out like the cherry on top. I never wanted to work with her. Yeah, she hosted the open house, but we thought that's open to everyone. There was a lot of people that came in, and he just sold it, literally sold it, and we ended up winning the case. We didn't have to pay not 1 cent to the company. So yeah, it was pretty funny. But it can go in a lot of different ways.
So I guess they look at not just the evidence, but the spirit of what's going on too, maybe.
100%. There's the black and white of the contracts, which the dispute resolution, and then there's the spirit of the law, right, or a spirit of the contract. Meaning, just because it says it in black and white, does that mean that it's going to go that direction? I'd rather be in a position that I have the black and white. But at the end of the day, it's what the buyer and the seller agreed to. Yeah. And I've seen where I scratch my head. It's like, can't believe that happened, but it happened.
About what's fair and what's equitable.
Exactly. So dispute resolution, which is, I'm not sure if this is now on the new RPA, Steve. I don't know if it's paragraph 22 still. But the dispute resolution, section 22A, talks about mediation, and it also talks about arbitration. So the parties agree to mediate any dispute or claim arise between them out of this agreement. And when we say agreement, they're referring to the RPA, okay? or any resulting transaction before resulting to an arbitration. So we must first try to mediate this before we escalate it to an arbitration. And you as an agent can diffuse that and say, look, based off the contract, the black and white, let's try to mediate this before we take it, because it's going to cost you more time, more money, and ultimately it's a gamble too in an arbitration. Okay, there's no 100% sure that you're going to win the case. So if we can avoid an arbitration, let's try to mediate. And 90 to 95% of the time, you could probably mediate it as an agent yourself, or bringing your manager or your broker involved into this, and then try to resolve this before it gets escalated.
So,
Make sense?
Could you say that, in the mediation, you have more of a back and forth type of situation where you can come to an agreement versus arbitration where here's the evidence and then the decision, and you're going to be bound by it, whatever they say in arbitration, correct?
Correct.
Well, and mediation is completely voluntary. It's decided amongst the parties, the principles of what they agree upon.
Yeah.
It's non-binding as well. Okay, so for instance, it's the yin and the yang in mediation. Your clients can leave a mediation meeting and there could be agreement, but they can get home that night, okay, and think about it, say, more on reflection, I really don't like that resolution, okay? They're able to then escalate it then, and that mediation agreement is no longer valid, okay? And then it goes to the next step. If the arbitration clause was signed, then it's able to go to arbitration.
Yeah.
But the mediation by, I guess, California, that's a car requirement that they go through mediation first, right?
Well, per the contract, yeah, that's what it says right here, that the parties who are would agree to a mediation before it arises to an arbitration. And also on this paragraph, it talks, if the buyer and the seller want to mediate it, you can go through the consumermediation.org, which is right here, and they can personally pick and choose a mediator. Now, it's at a cost, and sometimes it's anywhere from $75 to $200 per hour to have someone mediate and hear the both sides of the parties issue. But agents can also mediate, and I've seen it. An experienced agent, and I'm going to use Steve as an example. Steve, being a licensed broker, many years of experience, he can probably mediate this and come to a resolution. Because he understands the dynamics and the win-win and diffusing the situation. But at the end of the day, it's really what the buyer and the seller decide to do. Yeah. Now, I caution you that if you're considered a dual agent, do not mediate this, when you represent both parties, but if you're representing one party, your job, working with the other agent to try to navigate this. And most of it is like the request of repairs. You don't want it to cancel because you don't want to start over. You want to neutralize that position where the buyer and the seller continue with the process, because what is the end goal here? Seller sell, buyer buy, and you get paid a commission. So that's the win-win on this. And there's going to be a lot of walls and challenges through the entire process. You're going to have some smooth transactions, but then you're going to have some not so smooth transactions as well. This is where you can either say, look, let's just stop here. Let's take 2 steps back. We can get a mediation involved, or if you feel that someone did something, bad, then we just mediate it, and eventually we can escalate it to an arbitration. But what it says here is you may want to try to mediate it before you escalate it to an arbitration. Okay. Any else to add to that, Steve?
No. Well, actually, yeah. I think one of the big things to help eliminate even getting into those is just detailed communication with your clients.
100%.
The more they know, the more that they know what to expect. And then when it happens, whatever the topic happens to be,
right,
they're prepared for it, and you're able to remind them, we have talked about it prior, here's where it is, here's now how we need to approach it. Here's what we need to do.
Right.
Okay, so communication, and then you've been able to feel as though they have an understanding of what you're saying. Okay, it's typically at that point, I think, where a lot of agents get into trouble is not prepping their clients, but even if they think they did, it's on the basis of that they didn't get adequate feedback from their client that they feel that their client understands what they're saying. Okay.
Yeah, and it seems to me that the purchase agreement is just so detailed for that reason, that there's a good understanding on if
You're making Simon's point here that you better know that purchase agreement, you better learn it.
well,
Yeah.
yeah, I mean, it has everything spelled out, so that instead of like being a situation where you're trying to accuse someone of something else, it's an agreement or a body of information, so everyone knows what their position is, and you don't have to come into disputes when it's all your position is spelled out right there,
Yeah,
but it has to be communicated.
Well, and hence where agents can sometimes get into trouble with regards to the purchase agreement is when your client is only clicking DocuSign on the bottom of the pages,
Right.
and then they don't understand what it precisely was that they were agreeing to in that purchase agreement.
Sure.
right.
That they weren't explained and they hadn't understand, and then you didn't know that they didn't have an understanding.
Yeah, very good. So here's a paragraph of the purchase agreement that talks about 22B as in boy, arbitration of dispute. Now, this is volunteer, meaning that the buyer or the seller did not, thanks Steve, does not have to sign off on this, okay? So if you read, it says the parties agree that any dispute or claim in law or equity arising between them out of this agreement, meaning the purchase agreement, or any resulting transaction which is not settled through mediation shall be decided by a neutral binding arbitration. And the parties also agree to arbitrate any dispute or claims with brokers who in writing agree to such arbitration prior to or within a reasonable time after the dispute or claim is presented to the broker. The arbitrator shall be a retired judge or justice or any attorney with at least 5 years of residential real estate law experience, unless the parties mutually agree to a different arbitrator. The parties shall have the right to discovery in accordance with the Code of Civil Procedure 1283.5 in all other respects. The arbitration shall be conducted in accordance with Title 9 of Part 3 of the Code of Civil Procedure. Judgment upon the award of the arbitrator may be entered into the court having a judicial enforcement of this agreement to arbitrate shall be governed by the Federal Arbitration Act. Exclusions from this arbitration agreement or specified in paragraph 22C. Notice by entitled in the space below, you are here agree to have any dispute arising out of this matter, including the arbitration of dispute provision decided by a neutral arbitration as approved by the California law, and you are giving up any rights you might possess to have the dispute litigated in a court of jury trial. By initialing in the space below, you are giving up your judicial rights to discovery and appealing unless those rights are specifically included in the arbitration of dispute provision. If you refuse to submit the arbitration after agreeing to this provision, you may be compelled to an arbitration under the authority of the California Code of Civil Procedures. Your agreement to this arbitration provision is voluntary. We have read and understand the foregoing and agree to submit dispute arising out of this matter, including in the arbitration of dispute provision, to a neutral arbitration. Okay, and you can see that the buyer and the seller sign here. Now, Does the buyer have to arbitrate this? No. Does the seller have to arbitrate this? No. It has to be mutually agreed. And if one doesn't agree, then the other one doesn't have to agree as well. It should be signed and executed. Your job as a professional real estate agent is to make sure that they do sign this, because it protects you from them speaking with an attorney and going in a different direction. Because at the end of the day, it's the disagreement between two parties, a buyer and a seller. And if we as real estate professionals cannot align them to get into track or into position, then they must mediate or escalate it into an arbitration. Does that make sense?
Yeah.
Okay. The should arbitrate decision balance the scale, then decide. Share legal Q&A and similar information, but do not tell clients what to do. Remember, you're not an attorney at the end of the day. We do not practice law. We can only advise based on what the contract says. If it gets a little hairy, bring it to your broker's attention, bring it to your team leader's attention, and then let them handle it, or we can always escalate it to our legal department as well, so they can be involved in giving you and your clients some peace of mind in how to approach these contracts, okay? As I said earlier, it's all based on the scale of evidence. The more evidence you have, the more likelihood that you're going to win the case. Small claim disputes is $10,000 or less. No requirement to mediate or arbitrate. So if it's monetary damages that buyer and seller come to some type of disagreement, if it's less than $10,000, you don't have to mediate, you don't have to arbitrate. But if it's more than $10,000, then I suggest, get someone involved to mediate, or, escalate it into an arbitration. Okay. Additional resources, quick guides, the distinguish between mediation and arbitration for consumers, and then the legal Q&A as arbitration for consumers and mediation for consumers. All this stuff can be downloaded and given to your client as part of the process through the California Association of Realtors. Okay. Any questions?
Simon, I think did I read somewhere that it said arbitration is always going to be between
Record and go back to share. Sorry. I thought I had the presentation, but going back here. It's not going to give me access anymore. Let me log in real quick. For some reason, it's not allowing me access to it. Anyways, never mind.